Jim Crow period of our history up until Brown versus Board of Education was decided, which threw Jim Crow and Jane Crow for a loop and said separate but equal is inherently unequal in 1954. And then in 55, because the courts didn't give any guidance on how to implement Brown and the integration, the 55 court said, you must implement Brown with all deliberate speed. And that isn't much guidance. We could spend a whole other evening on integration and all of its successes and then its many shortcomings. But so we pushed through after the late 50s into what we call the civil rights era in this country, where we established the Voting Rights Act, the Civil Rights Act of 65 and 64, and the Fair Housing Act also of 1965, which banished and prohibited race discrimination throughout those agencies in our civil government. Well, it finally took, after Brown, it took 15 years before the 1970 merger occurred in 1970, when the white-only organization and the GT&EA organization finally came together and the modern GAE was born. And as Dr. Carter likes to say, you know, when we merged just a few years later, in 1975, that is when a competitor organization was formed because they did not like to share power with Black educators and especially with Black educators who were highly qualified and had PhDs and were actually more qualified than the folks that were, you know, part of the merger and were on GA's board of director at the time. So in 75, they formed their own organization. And you know the acronym, we call them Leaflet, but that is how Leaflet was born, out of trying to maintain the white power structure amongst administrators across Georgia. So some folks have seen these resources, but I highly recommend reading The Lost Education of Horace Tate. Dr. Tate was our first African-American executive director for GAE. The book is very, very enlightening. It details his life growing up in Jim Crow and what he had to do as a Black principal in all Black schools to gain access to resources the same as the white schools. And there's also some interesting reading in there about the merger, the pros and the cons of the merger. The merger passed by a 3-to-1 margin, but it's interesting to see the views of those who voted not to merge with GAE. One of the folks that did vote to merge with GAE is that second book, Hello Professor, Ulysses Bias. Another significant individual in the GT&EA and in the GAE merged organization. He was a highly, highly accomplished principal in the city of Gainesville, Georgia, just about an hour north of here. He had, his school was as good or better than the white schools. And so when came time to integrate the Gainesville City school system, they gave Dr. Bias a promotion to a central office job rather than put him in charge of a white school. And the talk at the time is, well, they're just not ready for a Black, highly credentialed, highly qualified Black man to be in charge of a white school. So Dr. Bias left. He and his wife moved to New York, where he became a highly successful principal for a school in the state of New York, which they eventually named after him once he retired. The last book, I just throw that in there recently, by Dr. Leslie Fenwick, Jim Crow Pink Slip, which talks about the implementation or non-implementation of Brown versus Board. And what her research does is to show, after Brown, the stories of Ulysses bias, essentially being run off or fired rather than put highly credentialed Black educators in charge of white schools. This book chronicles that whole story of our history, Jim Crow, Pink Slip. And I was fortunate enough to meet Dr. Fenwick the week before last at an NEA lawyers conference held in Washington, D.C., and got her to sign one of her books for me. So I was very, very, very honored to meet her last week. So I highly recommend these resources to you. They're GAE history. So the goals for tonight, we're going to talk about ESPs and what that means in terms of your legal rights. What does right to work mean? What is the at-will employment doctrine? We have to get into what are the waivers of state education laws, the sources of laws and our state statutes, open records, open meetings, federal employment law, and our First Amendment rights and social media. And as we go along, I think we typically ask people to put questions in the chat, and then Dr. Doe can distribute those as we go along. Excuse me.
And also, Mike, for the audience, if you are an ESP, please type what your job is in the chat so we can thank you properly, because we thank all of our ESPs, because we know our jobs would not be as easy as they are without the ESPs.
Exactly. Thank you, Sharon. So, right to work, I hear that term all the time and people throw it around, and I thought it'd be helpful to know what that phrase means in a legal context. And so for Georgia, state of Georgia, the legislature, obviously 1947, Jim Crow is still in effect. Blacks did not have the right to vote. And so we're dealing with an all-white, very white Georgia General Assembly. So they adopted in 1947, you can imagine a lot of Black veterans coming back to this country after putting their lives at risk over in Europe, fighting for democracy and freedom, coming over here looking for equality, the promise of equality under Brown versus Board. So here in Georgia, what they decided to do is put a set of anti-union laws on the books, commonly referred to as right to work. And they were designed to maintain the white supremacy instead of Jim Crow exclusionary laws here in Georgia. And what it really boils down to, right to work means you cannot be forced or compelled to join a union as a term and condition of employment. That's what right to work really means. And as we're going along and we're in a heated, political campaign now, the folks that want to suppress and divide always use the rhetoric of freedom and the freedom to decide, and they err on the side of saying, well, you shouldn't be forced or compelled to join a union. The worker should be free to decide what it is they wish to do, which really boils down to just a very slick rhetorical campaign to play up to what really amounts to keeping the playing field very, very unlevel and very, very unequal. So, and obviously, the consequence is that labor is divided. The playing field is not level, still not level. And so the labor, I guess, movement in Georgia is at this point in time still very weak, because we have right to work laws on the book. And there's a good resource down there. It's in smaller print, but put out by the Lerner Center for Public Health at Syracuse University, all about the right to work concept and doctrine and how it affects Georgia's teachers. So if you want to take a screenshot or take a picture with your camera, you can do that and Google that that particular resource and read up on it. I think you'll find it very illuminating.
And Mike, I want to make this kind of like a dialogue in case people are on their phones and they can't use the keypad to put their questions in the chat. Unmute yourselves and ask your questions when you have your questions. Because as I was listening to Mike talk, and he was saying that the playing field is unlevel or uneven. When I was talking to a member at our GAE fall conference this past weekend, this member was concerned about the retirement system. And Mike, in your presentation, will you please discuss some of the things that we can do as GAE members to try to even that playing field a little bit?
Yeah, I certainly will. When we, a little bit later on, we talk about First Amendment rights, rights of free speech and right of association, and what we can do collectively together. I mean, this slide begins that conversation. So we have right to work. It says, I can't be forced to join a union, but can we still form a traditional union under federal law? And my answer is yes. And it takes the strength of numbers and organizing. Right to work. It's a popular misconception that you cannot bargain. No, you can bargain without a collective bargaining agreement. You know, how many of us have bought a car, or bought a house, or, you know, you bargain and negotiate practically every day, or even with each other. You know, you trade out, you know, maybe a bus driver wants to trade a route with another bus driver. You bargain and negotiate. So we don't really need collective bargaining laws to actually bargain and negotiate with our local boards of education or with the state legislature. And I put in another popular misconception in my mind, and I might be a majority of one here, that Title 20 prohibits collective bargaining. People like to point out this language, which is actually in the state complaint statute that says nothing in this part. The complaint statute is another word for complaint, is grievance, shall be construed or to permit or foster collective bargaining in yada, yada, yada. But however, that section's never been interpreted by the courts. And even that language says nothing in this part. So this part means the state grievance statute. It has nothing to do with, can we engage, you know, under the National Labor Relations Act, hold an election. But before you hold an election to form an actual union, we need at least 50, 60, 70% members in one particular local school districts to have the power to have that vote and have it stick and get the respect of the Board of Education. There was a Georgia Court of Appeals decision in 1974 where there actually was a union in Chatham County. Chatham County, the local at that time, held a union vote under the National Labor Relations Act. And they actually won. And the local Board of Education recognized the Chatham local as the union representative for all of the school employees at Chatham County. This was, you know, the election was held in 1971. And a few months later, the board voted on a resolution to give the union close to $340,000 that they could do to devote to salary increases or purchase, I think it was life insurance at the time. So they did that. There was an actual union, collective bargaining agreement. Collective bargaining agreement spells out all of the terms and conditions of employment of all their members. Well, the local board refused to actually write a check to the local union, and the union then sued the school board saying, hey, we had an agreement, we formed a union, we did our part, you passed a resolution to give the union this pot of money that we could use to devote to, you know, salary increases and make those types of decisions. And so there was a lawsuit, and the trial court said, no, the board is created by the Georgia Constitution to administer the laws and the rules and the policies of the local school district. And they came up with this argument saying that because there is school boards are formed and created by the Constitution, they cannot delegate this spending authority to a third party, meaning the union. And so it was declared that the resolution and the union was null and void. That was the story back in 1974. And but to me, a lot has changed since then, because we have a lot of school boards making third-party contracts with cleaning companies, with bus companies, school bus companies for transportation. They even have contracts for placement agencies, bringing teachers in from other countries to teach here in Georgia. Well, to me, that's a delegation of authority. So in my mind, we still have a right to collectively bargain if we have the numbers. And the other way you can get the law on our side is to have the state legislature, the General Assembly, adopt enabling legislation, passing a law that says public school educators have the right to collectively bargain. And once the state legislature adopts enabling legislation, then the gates are wide open, and there's no disputing whether or not we can actually form a union under the National Labor Relations Act. So right to work, again, that means I cannot be forced to join a union as a term and condition of employment. So what rights do I have? And that's what we're going to start pivoting to now. We have rights, ESPs have rights, mostly under federal law. Your Title VII anti-discrimination law, it's illegal to discriminate on the basis of race, sex, gender, ethnicity, national origin. The Family and Medical Leave Act is a very strong law, another basis for rights. The Americans with Disabilities Act, another federal law that applies to our ESP members. Obviously, the First Amendment, free speech and association. And the Fair Labor Standards Act, wage and hour laws. I was teasing Dr. Doe before the show began because she was grading papers as we were getting ready. And I said, gee, I'm going to be talking about the overtime provisions of the Fair Labor Standards Act. And she knew right away, I'm not eligible for overtime. I'm exempt professional under the FLSA. And unfortunately, Dr. Doe is grading papers, but not getting any additional pay for that because the federal law exempts her as a professional educator. And there is a state whistleblower law that can provide some protection under that particular law, where if you are complaining about illegal activity, say, in your school district, and we have documented evidence that you are retaliated against for voicing concerns and complaints about illegal activity, there is a state whistleblower law, OCG, Official Code of Georgia 4514, that can come into play to protect our ESP members. So we've
Mike,
taken
the
a look.
important thing here too is, in order for them to blow a whistle, they have to know what their rights are. And that's where organizations like GAE comes into play, because GAE will inform you of your rights and how to go about making sure that your rights aren't violated. I know that in my district, whenever there's someone out and they don't have a sub, or someone has to go home for an emergency reason or something like that, many times the first thing they'll do is go and get the parapro
Mm-hmm.
and send the parapro to watch that class.
Mm-hmm. Mm-hmm.
So in your presentation, can you also address those type things that are happening?
Yeah, I most certainly can. The whistleblower law says if you have to make your complaints to the high level decision makers in the central office that, hiding or concealing, misspent monies. Money is usually the thing that you see in the reported appeals court cases where government employees are blowing the whistle on the way money is being spent. That gets the court's attention, and those complaints need to be put in writing to high-level decision makers. A good plaintiff has nothing in their personnel file before they blow the whistle. After they blow the whistle, they all of a sudden get negative evaluations. That's your classic, fact pattern that you're looking for when you're, evaluating a plaintiff for the purposes of filing a lawsuit, a retaliation lawsuit. But if you have other examples as we go along about non-compliance, non-compliance or what you believe are in good faith or violations of state or federal law in your workplace, the state whistleblower law can, again, bring in some protection. It doesn't mean they won't retaliate. It doesn't mean we can actually prevent it, but there is a remedy provided by the state whistleblower law, which gives the individual a private right of action to sue the government, which is a pretty powerful weapon to have.
Mike, we have a question from Michelle Favors.
Hi, Michael. You mentioned, and I'm gonna throw it off in now also. You mentioned wage and labor. She's not a member yet, but I'm going to sign her up. This issue that DeKalb County has with overpaying, underpaying, they are taking monies away from, well, this is a driver that I know that is a driver, taking monies away from drivers without any explanation as to why they're taking it away, when they're going to take it away. It's just all of a sudden they notice it's coming out of their pay with no explanation to say, okay, we overpaid you these number of days. This is when we overpaid you, and the amount we overpaid you, and this is coming out. Money just showed up in your account, which, hey, thank you, with no explanation. When you do look at munis, it does say to the extent that it's what it's for. But this particular person said money came out and with no explanation. And they don't have any, she said, well, they won't give me any documentation of what they overpaid me and when they overpaid me.
Mm-hmm.
There's no checks and balances of the number of days and when, where, and how
Right.
they were all paid. So that's the issue. And bringing up the member that talk about retirement, that was me also. But I was also speaking from the number of members that I constantly hear from. And I understand about the PSER and the 50 cent and the no cap, but for a lot of people that just does not move the needle, for them to get excited about it. And even speaking on this call, and I'll digress. Speaking on this call, this is an ESP rights Zoom, but you have some ESPs that are able to pay into TRS, and you have some that are not. There's some cherry picking when it comes to ones that can and ones that cannot. Like a plumber that just became a member, he was like, there are some people he encountered that are able to pay into TRS, but him being a plumber and he has no contact with kids per se either, just like the other job titles he was speaking on. But there's some cherry picking as to which ESPs can pay into TRS and which ESPs cannot.
Well, so yeah, that's a lot, Michelle. And I know the issues about the pay, you know, for those who aren't aware, there's a new superintendent sure put his foot in it. He used a software program that was known to be essentially defective to begin using this software program to pay folks, all employees, not just the ESPs, but the teachers as well. And it's just blown up in his face. And, you know, you're the ODE president, Deborah Jones. I've seen her on television a couple of times getting interviewed by local television, raising awareness. And so she's doing a good job advocating. And of course, our UNISERV director assigned to DeKalb, Taya Donald, is also advocating on a case-by-case basis on behalf of members who have been overpaid or underpaid, trying to get answers, you know, trying to get answers and try to straighten this out so that, you know, people are going to be paid, you know, honest dollar for an honest day's work, no underpayment, no overpayment. But that's a big issue, and Deborah is advocating, and I think you've got school board's attention on that. But we got to keep swinging, you know, that if you got a new member there, great.
I guess what my question is, in the meantime and between time of the fighting, under the wages and labor laws, doesn't that employee have a right when you take monies, when you change a timesheet, which I didn't think they could do, but when you alter a timesheet after an employee has signed it and turned it in, as far as, doesn't that employee has the right to request documentation when a subtraction, a deduction has been taken out of their pay?
I'm on a Zoom.
Oh yeah, 100%.
So they can't just say, well, we have no account. We can hear you, Jack. They just can't say we have no accountability, no checks and balances to show you why we deducted, what we deducted, when we deducted, and what we deducted for. So who does she isn't a member yet, so she doesn't have Taya to reach out to. So her other recourse would be what? Because I'm not asking just for the non-member, I'm asking for some members that's happening to also.
Oh yeah, no, I don't keep up with how many members, but it's dozens and dozens and dozens. It's a big issue in DeKalb. Now they have a right under the Open Records Act to request those documents, just as you're saying. I mean, that's advocacy and organizing 101, and I'll get into the slide on that, but to your point, those are public records. Period. Put a pin in it. They have the right to request that stuff. I mean, that's the short answer, but
they have to do it through the Open Records Act.
Yes, ma'am. Yep. I have a slide or two on that. Michelle.
Okay.
It's a
Okay.
power, it's
Mike,
a,
I see one more question
all
from
right, okay,
Jacqueline Madden.
Jackie Madden.
I'm
All
on
right.
Zoom. Hello.
Jackie, ask your question, please.
Hey, how y'all doing?
Hey, how are you?
I'm good. I was at the county office today, and one of our bus drivers was up there, and she was trying to get her pay stub, the $2,000 they gave us for what, retention money. She said that the DeKalb County had it on her check stub as a gift. So she was trying to figure out, well, if that's a gift, why did she get taxed for it? And at the end of the when she get ready to file her taxes, she said they're gonna put her in a different tax bracket. So she's supposed to call me back. I'm gonna get back in touch with her and see what happened on that end. See what they said about that.
Okay. You might find out how other districts are treating that retention money. That's the first time hearing that they're treating it as a gift, which is taxable as a gift under the IRS law, rather than treat it as, payable compensation, and then they take out the standard deduction. So I don't know. I don't know if it's.
So I'm gonna find out about that.
Yeah, good. Right.
So
Okay, that's all I.
There's
Okay.
a question from Ms. Stubbs that says, what employees still sign their pay or time? And I would think that different districts do different things based on their accounting practices.
And could you repeat that? I didn't really catch it. Something about timesheets or?
Yes, what employees still sign their pay and time?
What if
Saying
they?
that she wasn't aware of this practice, but different districts have different accounting practices.
I see. Right. Yeah. Some use I guess a computer method. Others use. I've heard of some districts using a thumbprint reader to check in and to check out. And some use like I guess here, pen and paper, that sort of thing. But there's no, I think you're right, Sharon, there is no law that mandates a particular way that employees are required under law to sign in and to sign out. That's right. It's up to each district. So it's going to be all over the map. Yeah.
No more questions.
Okay. I appreciate the questions in the comment. So let's see.
Wait a minute. I have one more question as far as what Jackie was saying. So the line item that the governor touted and that the county received the money under to give to the employees was supposed to go on the line item for, well, they put it on the line item for retention pay. Like on mine, it says retention pay, EE retention. That's what it employee eligible retention. That's what the line item on Munis is. So how is it that this is a bus driver also, Jackie? Hello? Did she go? So how is it that one employee is listed as a retention, which is what they sent in email form and what they voted on? Employees would get in their business meeting, employees a $2,000 retention bonus for anyone that was 25 years and under, well, 24 years and under. So how is it that one employee as a gift and other employees is listed as a retention? How is that possible? So is that just a clerical error?
Well, that's the question that should be posed at the next school board meeting. I would, that's my suggestion. But it's not very consistent.
Yeah, I would check. So well, I guess that employee, like right now, because you can't ask the board questions and then get responses from. What can she do? She needs to go back to payroll and say, wait a minute,
Well,
this was touted as a retention bonus and you all putting it as a gift.
she can go to the board and say, this is what happened, and needs to get it on record in a public forum. So these board members are clearly aware and put on notice that you got some serious issues here. Now, the board members may not respond, but the point is getting this on record. And so that's why I'd suggest going to the board. And then the other, practical, immediate thing that's less political is going to the payroll office and saying, hey, and maybe they would be gracious enough to have a group meeting, right? Instead of, one member to another member and cycle them through individually. Maybe try to approach it through a group method where if you have an email list, send an email out asking folks to, meet up at wherever, if you've had these payroll issues, sign them up, get a sheet, a sign-in sheet, and then everybody talk about their individual issues, write them down, and then take that to the payrollers, whoever it goes to, and say, look, we have these common issues here. It would be efficient and in everybody's interest if we had a group meeting with these common issues and that people could ask the questions in a professional and civil way, so that we can all gain a better understanding of what's going on, because people want answers. People want answers.
Yeah, we're hoping to do that, and I will refer to it as a sip and talk. We sip on some juices and talk about it.
Okay. Well, good enough.
I do see Mr. Anazel Bay has come to the meeting. I do want to recognize him. Mr. Bay is the liaison, the staff liaison for the state ESP committee. Mr. Bay, are you on?
Can you hear me?
Please introduce yourself.
Hi, everyone. Excuse me, my apologies for this tardiness of mine. But either way, let me introduce myself. My name is Anazel Bay. I'm the current liaison for the ESP. I'll say efforts on trying to make things change. I went to the conference this year. One thing that I do here is a commonality. They have this program where they're calling the Bill of Rights, where it kind of took all, let's say, the problems of ESPs all over this country and kind of going to figure out how we can collaborate with our problems that we have here in Georgia. Excuse me, that's my dog.
Okay, Mike, back to you.
Okay, so we looked at the right to work, and that just means you can't be forced or compelled to join a union as a condition of employment. That's different than what this at-will employment doctrine is from a legal point of view. The at-will employment doctrine basically means that you can be terminated from your job for a good reason, a bad reason, or for no reason at all. That is what at-will means. It means that either party can walk away from the job. I can leave the job at a moment's notice, but I'm entitled to the pay up to that moment. And the employer can let me go. for a good reason, a bad reason, or no reason at all. And I put this slide in, you can read it. This at-will employment doctrine goes back to the court decision in 1853 during the slave and plantation times here in Georgia. And you can see the overseer sued the plantation owner for wages that he said he was owed, but the court, Georgia Supreme Court, said, well, that's nice, but you don't have a contract. You have an at-will arrangement where either party could walk away from the job. So he lost his case. And, you know, one of the reasons I put that in there is nothing's changed since 1853. That law there, Henderson v. Stiles, that's the law of Georgia right now. And if you want to read, again, Google Deborah Ballum's paper, Exploding the Original Myth Regarding At-Will Employment, and it'll be eye-opening. Again, it is a racialized perspective of the at-will employment doctrine and what it has done to folks without power. And in those days, it was predominantly people of color, African Americans, and it's been used as a tool ever since 1853. So I just put that in there just as a little education. So with knowledge comes power, should come. So the at-will employment doctrine, again, here we are in 1910, Jim Crow South. We're going to enshrine the court decision, that 1853 decision. You're going to see that put into the legislature by the all-white legislature in 1910 as a way to keep the working class down and specifically keep the races separated. Here in the South, Georgia is one of the only states in the United States that doesn't have any exceptions to the at-will employment doctrine. That sentence you see there, an indefinite hiring may be terminated at will by either party. Other states have various exceptions to that built into their statutory schemes, but not Georgia. And that's why I throw in at the end, you know, whom we elect or who we elect matters. It's up to us to put the pressure on the state legislature and on local boards of education to change laws and policies, because that is where our rights are created. Well, speaking of creating rights, I just spend just a moment here. So we're in a waiver era where our legislative geniuses have passed education laws for the past, you know, decades and decades and decades, only to turn around in 2015-16 to say, you can waive any education law you want to. Hits, you know, class size. If you want to waive class size, put more kids in the room, but don't hire more teachers and paraprofessionals, you know, go for it. You can waive the law. So one of the lessons I'm trying to teach, though, on this slide is they can't waive those federal laws that we're going to talk about. But when it comes to Title 20 laws, their class size, your state salary schedule, for teachers, the fair dismissal laws, that you need to check whether or not your local school district has waived those laws. And I always want to say, what the local school board waived, they can unwaive, they can amend the agreement that they have with the state to reinstate class size regulations, or reinstate the duty-free lunch law, which gave teachers in grades K through 5 a 30-minute lunch break without having to supervise students. So we have the power, but we just have to organize and use it. So again, the sources of our rights, we're going to look at federal statutes, state statutes, Board of Education. Again, the lesson is who we elect matters, because all of those, our rights, come from our elected officials. Our school board policies mostly are online today, but you can also check at your worksite location, the central office, and always check the worksite and the central office, because they will maintain two separate like hard copy files in both locations. So if I say I want to see my personnel file, I'm really asking to see two files, one where I work, where I'm housed, where I go show up every day, and at the central office. So some of the policies will govern transfer rights or layoffs and grievances. Many districts, but not all, have grievance policies that give classified employees, our ESP members, the right to file a grievance. And a grievance is another training on grievances. It's a violation, misapplication, or violation, misapplication of a state law, a federal law, or a local policy that is caused harm. And there is a process that you go through that the complaint policy or grievance policy will allow individuals those avenues to flesh out their problems. And usually there's like a window of like you only have 10 days from the date that you were harmed to file a grievance. So like these issues that Michelle and Jackie were bringing up earlier, I'm assuming the 10 days is already passed. And I think DeKalb does have a grievance policy for its classified employees, but keep that in the back of your mind as problems come up. Yeah, we can go to payroll, but we might also have time to file an actual grievance over it. Because if we don't exercise our rights, then there really are no good. Our state statutes can be found at that website. It's the State General Assembly, and it's a very easy site to navigate. I use it all the time. Open Records Act, getting to, I think, Michelle's point. Just about everything you do on the job is a public record. The exempt information is what cannot be released under the Open Records Act to outsiders. Our home addresses and personal telephone numbers, social security numbers, insurance and medical information, and personnel evaluations. I have a question mark there because there's a conflict in statutes. The Open Records Act would say that personnel evaluations can be accessed, say, by anybody, by a third party, by a parent group or a newspaper. The state evaluation statute, however, states that personnel files and personnel evaluations are confidential. But in every case that, I have seen, when it comes to a conflict between the state evaluation statute and the Open Records Act, courts are gonna say, well, the Open Records Act trumps the personnel evaluation statute, and will disclose the employees' personnel evaluations to those people who
lost his daughter because he was so attached to his own idea, his own ideology. Love some idea more than their own child, but this is a limited man we're talking about. He's someone who's
Okay, I was hearing some background noise, I guess. So personnel files, remember, includes written records, but also electronic emails. You can request emails concerning your employment. For example, you can even request the superintendent's text messages or emails. But just know that when you do that, you may be incurring costs that may be beyond what your ability to pay is. But just know that if you're interested in email traffic between parties in the school district over your employment, that you can gain access to those, although there may be a cost attached to it. So there may be things in your file you've never seen before. It is rare, but it does happen. If you do see something in your file that you haven't seen before, you can always attach a response or a rebuttal to it. And there's no statute of limitations on attaching a response or a rebuttal statement. So that covered the Open Meetings Act, or excuse me, Open Records Act. Open Meetings Act, again, we all have rights as citizens to attend school board meetings. They can limit it to matters of public discussion, but not personnel grievances. Personnel matters usually go into an executive session. However, I think what Michelle brought up, if an employee raises up the general issues concerning the payroll mess that's been created, they have a right to go and air that in front of the board. I've seen Deborah Jones do it. They don't try to shut her down. They let her say her piece respectfully. Deborah's very respectful. She'll say her piece, and then she'll get her, whatever it is, 2 minutes, and then she'll sit down. And you could have somebody come up behind her with their take on the situation too. So this might be a little bit of overload, but these are general statutes that apply to our classified employees, our ESP members. I decided just to do this rather than go through create a slide for each one of these, but you can read. Obviously, a code of ethics would cover a paraprofessional because they have a license from the PSC. A letter of reprimand can only be written by the superintendent. So if a principal writes a letter of reprimand on the performance of an ESP member, they can't do that. They're going to have to rewrite it and recharacterize it, say, as a letter of direction. They cannot write a letter of reprimand. The school assault sick leave statute says that teachers and other administrative personnel, without defining that term, if they are injured at work by being assaulted by a student, they cannot be charged the first 7 days of sick leave. Then we have our bullying and cyberbullying statute that applies to ESPs. Student code of conduct applies to our ESPs as well. It covers verbal assaults, physical assaults, disrespectful conduct, and bullying as well. You should become familiar with that. And if a student is in violation or non-compliance, then we need to hold that student accountable through administrators who are going to back up these violations. So there's also 2 statutes that are of interest in the criminal code in Title 15 and 16, that the language specifically prohibits battery, assault and battery against school employees, including bus drivers. They've got that language in there, but it covers all ESP members in the criminal code. So those are a set of safety laws for the most part that apply to our ESP members. Workers' compensation is another state law protecting ESP members. We do not provide legal services for workers' comp, but if you're injured at work, then you do have a right to apply for workers' compensation, a slip and fall, or even if you're injured in the line of duty through an act of violence, you can apply for workers' comp. You should seek medical attention immediately, notify your supervisor, and complete the forms And of course, it only provides a 2/3 income benefit, and the medical benefit, you know, your doctor's visits and physical therapy, fit visits are covered. A lot of people don't know you actually get reimbursed mileage going to and from the doctors or your physical therapist. And I just looked it up today. It's 67 cents a mile in 2024. And when we get into workers' comp, if you don't know a workers' comp attorney, we can, you know, help you find one here in the metro or anywhere in the state, really. And when somebody is injured, it then brings up those two other federal laws that we had referenced earlier, the Family and Medical Leave Act and the Americans with Disabilities Act. So the Family and Medical Leave Act covers employees who have serious health conditions. It can't be a, you know, minor cold or a minor flu. Everybody, I think, hopefully most people are familiar with it by now. You know, if you have cancer and you need intermittent leave for cancer treatment, that's covered by the FMLA. It can be unpaid. However, you can use paid leave if local leave allows for it. FMLA for folks who are eligible, if you have a serious health condition, there's always paperwork to fill out that your doctor has to certify that you are being seen by him or her for a medical condition. It doesn't have to get into a whole history. Sometimes districts get the medical certification. They'll come back to the employee and want access to your whole medical history. No, they don't have a right to that. They have a right to what the doctor put on the form. And it may be something out of the diagnostic manual, which is not disclosing a whole lot, right? But it's telling them from a medical provider, a doctor, that you are being treated by him or her, and you have certified to that statement on this official government document. And they're doctors. They're not going to subject their license to any discipline. So they can't go probing into your medical history just because they want to go fishing around for things. So that's the FMLA. The Americans with Disability oftentimes comes into play when we have serious health conditions. Two good resources there at the top. The ADA.gov is just tons of information about requesting accommodations, what is an accommodation. This other group is also fantastic, askjan.org. They're a private nonprofit organization that's been around a long time, and they're an advocacy group that, at least on their website, they have tons and tons of information about the Americans with Disabilities Act. Both those are really super filled with information. So I just put up some real simple examples of what an accommodation is, and I should put in accommodation. It has to be a reasonable accommodation. It's not my wish list. It must be a reasonable, and these are real simple ones that generally no controversy over. Like if I have arthritis in my knees or my feet and I'm a teacher or maybe a parapro, whoever, and my doctor, and I need to sit, and my doctor recommends that as a reasonable accommodation, that generally districts got to allow that, even though part of my job description is to circulate around the room. You may have lifting restrictions if you have, lower back issues, like who doesn't, speaking for myself. If you're diabetic and your school prohibits snacks in the classroom or on the school bus, the ADA says, no. Diabetes is a serious health condition. It's a disability. The snacks are there to level the playing field and give this individual with a diabetic disability an opportunity for a fair and equal playing field. And of course, if you're asthmatic, a simple, reasonable accommodations to have an air purifier in your room. You know, well, you can go on, you know, at length with that. You can ask for, you know, a different room, you know, or if you have carpeting in a room, do they need to change the carpeting, or are the ceiling tiles moldy? You know, do they have to replace those ceiling tiles? The only defense to a reasonable accommodation, if it imposes an undue hardship, and you know, that really rarely comes into play. Where it kind of can come into play is that you have no bumping rights to bump somebody out of a position as an accommodation. But undue hardship in a public school setting is really kind of a difficult defense to be successful if you're representing a school district, because most of these are really simple. I mean, that's all we're just asking for the little things, because we want to do our job. You know, we're there for the kids. So,
Mike, we have a question in the chat.
okay.
It says, does the mileage include professional development planning?
Well, under the workers' comp, no, that would be to and from doctor's visits for workers' comp purposes. The question may be going to not so much mileage, but hours worked under the Fair Labor Standards Act, because our ESP members, classified employees, at-will employees, are defined not as a professional under Fair Labor Standards. Dr. Doe she is a teacher. The law exempts her from the overtime provisions of the Fair Labor Standards Act. So I'm kind of jumping ahead, but this question about mileage going to professional development, you have to be paid for that time. Now, if you're using your private vehicle to get to and from the professional development, I would wonder, yeah, I'm getting paid for it, but what about mileage, the wear and tear on my vehicle? I would definitely be pushing the district to compensate me for the mileage that I used in my personal vehicle. If they were making me or requiring me to use my personal vehicle, I think I have a pretty good case for saying you owe me some mileage. If I say, you know, rather than take the company vehicle, I'm going to take my personal vehicle, then that, you know, that's on me. That's going to be on me. But the idea under hours work, and I'll just jump to the questions I have on the next slide. So
Okay,
school
we
bus.
have one more question.
Sure.
Michelle Favors has her hand up.
All right.
Okay, speaking of accommodations, this is not a rhetorical question. This is actually has happened to me and others. And one particular lady is dead and gone now, unfortunately. Certain older buses or certain units that's available hurts my back. She said it will hurt her back. So if my bus goes down and the only available unit to me is a unit that will further cause pain or further injury to my person, to my body, can I still come to work and stay on the clock until I'm accommodated? And I do. One of my doctors have put it in my return to work conditions of having a particular type of bus. So to say that, so do I like, okay, this bus here hurts my back, hurts my knees to operate. Well, we don't have anything else available. This is all we have available. Am I still able to stay on the premises on the clock until a unit that can accommodate my injury or my disability?
If they allow it, because technically they're saying you cannot perform the essential functions of the job, and they don't have a reasonable accommodation in your capacity as a driver. Now, they could put you to work, you know, in the bus barn, you know, continue to perform some sort of labor so they can justify your driver pay, right? So they could do that, but technically sounds like you can't do the job, and they don't have another bus that can accommodate you. They'd have to, I suppose, purchase another bus. And that may be that undue hardship we're talking about, that looks at the cost of accommodating an employee. And I don't know what does a new school bus go for?
Well, I don't know as for, it's up there. It's up there per unit depending on what they put on it, but like until my unit gets fixed, sometimes there's no haste, there's no real push to get units repaired sometimes. So I have a unit that will accommodate my disability, but it may be broke down, or it may be something maybe have an issue with it where I have to take on another. So if they're saying there's not a unit available to accommodate me, would I be able to in turn, whether I stay on the clock or not, would I be able to in turn use sick leave without a doctor's note? So it's like, say for instance, my unit gonna be down a whole week.
Mm-hmm.
I don't have to have a doctor's note for that because my doctor has already said I have this ailment or this disability. So would I in turn be able to use sick leave without having to provide any more documentation?
My answer would be yes. That's my answer.
Okay.
And Mike, a school bus costs between $25,000 to $30,000, but with maintenance and upkeep, it could be more.
Yeah. Wow. Yeah, that would be, well, yeah, I can't imagine a court directing them to purchase a new bus for one employee. I mean, I wish they would. I wish our, you know, the whole issue of underfinancing public education is just, you know, it's not a new one, but it's very real. And it's exactly what Michelle is talking about. You know, but a bus that could accommodate her is broken, and it takes time to fix it. You know, I understand that. You know, but I begin to wonder, well, how long are they going to continue to fix this bus? How old is it? And when are they going to be purchasing some newer buses? And it isn't just about Michelle, it's about the kids as well. I mean, if there's something wrong with the driver's seat, I'm imagining there are other issues that relate to student safety as well. So that's a good question. I appreciate that.
Yeah, like even to put another, if you don't mind, another tag on that. They may not see, we're in Georgia. Climate change has changed the ozone over the past 44 years. They don't see air conditioning as a safety issue, but in actuality, it is. When you have a driver that's overheated, and you have kids, that's a safety issue. Mm-hmm. So that may also be something that we can work on at the state level. I don't know how that would go about to mandate air conditioning.
Yes, you know how to go about it, but it's not just Michelle on her own,
right?
Gonna do it. It's a whole bunch of us getting together, staying unified as one. And that's you know, that's the answer. We just got to get the people involved. So the answers, I hope everybody has figured out my complex quiz here. So yes, bus drivers do have to be paid for their pre-trip, post-trip inspections. Yeah, and you have to be paid for waiting time. There's a The U.S. Supreme Court in 1944 said an employer can choose to hire a person to do nothing or to do nothing but wait for something to happen. I just love reading that out loud, but that's our U.S. Supreme Court back in 44. I don't know what they'd say today. They're a mess right now. Can a paraprofessional be directed to supervise the lunchroom without pay after punching out for lunch? So I punch out for lunch, and then my principal tells me to go into the lunchroom, eat my lunch there, and supervise the kids. That's called fraud. So no, can't do that. What about attending training as required by your employer? I think I kind of heard that in the question about mileage to professional development. They got to pay you. If they're directing you, you must attend professional development. You got to get your pay. Now, getting to and from, that's another issue. In my mind, if they're directing and requiring you to use your personal vehicle, I would do it if you're going to pay me the mileage to do it. You know, otherwise you're going to pay for my Uber or whatever. So in a Fair Labor Standards Act for I guess a case of simple negligence, the employee is eligible for up to 2 years back pay. And for really serious intentional violations of this law, the employee can get up to 3 years of back pay. So I know I'm already over time here, but we're having a good time with our discussion. So we want to hit on the free speech. It doesn't give us, it's not absolute, obviously, and it doesn't give us the right to say whatever we want to whomever we want. So we want to do it intelligently. First Amendment, generally, the strongest protections are when you as a public employee speak as a private citizen on matters of public concern. So we're talking about, you know, going to the school board meeting, and if I live in DeKalb, I'm paying taxes, I'm a citizen of DeKalb, I vote in DeKalb. You want to, when you get up to speak, you might want to say all of those different statuses that you have to give you buffers and layers of protection that cover you as an employee. So you want to make sure, hey, I'm here. Yeah, I'm an employee, but look, I'm all these other things too, and I have a right to be here. And I'm going to tell you, me and a whole bunch of people are having issues with this, whatever that software is, and it's causing a problem. You need to be aware of it. Or, hey, have you heard of climate change? Guess what? Not having air conditioning on these buses is an actual safety concern. We need to do something about it. So it's, I don't want to spend a lot of time on this slide here, but like I said earlier, it's not an absolute. There are limitations. If my speech is part of what I'm supposed to do in my job, the United States Supreme Court in 2006 said there's no constitutional protection there. You have to look at your state whistleblower law. There was another case through a former president, Jeff Hubbard, when he was the state GAE president, he criticized the Clayton County School Board because they lost their accreditation, and they took away Jeff Hubbard's release time agreement that he had with GAE, specifically saying is that we don't like your criticism of the school board. Well, that was Jeff's, well, he was doing that as the GAE president, not as an employee of Clayton County Schools. And so we ended up filing a lawsuit and winning. And of course, you can't say anything that's unlawful or untrue, defamation. and this is just a case where this is not a GAE case, but a teacher in Tifton, her name happened to be Tucker, and on her own time during a weekend holiday parade was saying some very nasty, nasty things about Black Lives Matter folks who were peaceably marching during the parade. And she said some very, very nasty things about, you know, taking your hoodies off, pulling up your pants, and just a lot of things that I don't want to repeat, but it caused a real disruption at her school, teaching predominantly Black students at the middle school. And the court said, yes, you were on your own free time, and yes, you can criticize the Black Lives Matters if you wish to. That's a public concern, but it caused an uproar at the workplace amongst your own students and your own parents in the African American community, so they dismissed her lawsuit. Now, this is a case involving a bus driver out of Gwinnett County that we did 10 years ago or so, and I'll let you read here. But what's interesting is that Elizabeth Cook, her name was Elizabeth Cook, she was the president of USEA, that was the bus driver local at the time. Gwinnett had their bus drivers had their own local association. The United, I'm drawing a blank. It was the United something is, who's on the call from Gwinnett? But it was the bus driver local. She was speaking on behalf of the organization to improve the safety, like Michelle was talking about, air conditioning on the buses, saying it's a school safety issue. So that was some of the protected speech. Now, notice that Elizabeth, while doing this, was not disrupting the workplace, and she was not neglecting any of her specific job duties while advocating for safety conditions on the job. And she recruited her other fellow bus drivers to join USEA, and she did so to improve a variety of conditions, not just for herself individually, but collectively, right, on behalf of her fellow drivers, as well as the students. Now, this goes to your point, Michelle. What do we do about it? Well, we go to the state legislature and we lobby the Capitol on behalf of bus drivers. That was evidence in her lawsuit. Also evidence was the photographs that she took on our, what do we call it? The annual lobby day at the Capitol, GAE Day at the Capitol.
GAE Day at the Capitol.
Right, taking photographs of herself with all of the other bus driver members. That was actually used in the lawsuit to show that we're not making it up. She was advocating as the president of the legislature, to pass laws that we're going to, because of climate change, Michelle, we're going to make sure that they pass a law that give us money for air-conditioned buses. So important, I want to stress now, Elizabeth did not engage in any union-related speech while transporting her children or performing her duties. She did her job. A lot of the speech was during wait time and downtime, when she would talk to other bus drivers about the safety conditions while she was waiting, you know, in between her morning and afternoon route. The other important thing, there were no negative evaluations. As you know, as an at-will employee, you can be let go for any reason. And if she had one negative write-up, that may have been enough for a court to say that that's why in her case, they demoted her. She was a team leader and they took away her team leader status because she was persistent and vocal on the job, but she didn't disrupt the workplace. She did her job, no negative evaluations. And they also let other organizations to have flyers distributed at the bus barn in Gwinnett. I'm thinking the one I remember was United Way. Well, if they're letting putting United Way flyers in people's mailboxes, they could allow the local bus driver association to put, join USEA, join the Gwinnett Association in the mailboxes, and they could not punish her for that. So coming to the end, now what? So if you think your rights are violated, you contact our UNISERV director and ODE. I guess I'm thinking of ODE because we have 2 ODE drivers, but you contact Deborah Jones, full-time release president. Then they work closely with, with me here in legal services and our network attorneys. So, the mantra is we're in this together. We are stronger together. And we appreciate your time tonight and your patience. And there we go. I think that's it.
All right, Mike, thank you so much for that information. That's very important information that GAE is committed to providing you so that you know what your rights are. If you have any questions, you can drop an email to Mike McGonigal at mike.mcgonigal@gae.org or lisa.morgan@gae.org. I want to thank everyone who attended this meeting tonight. I know that you guys appreciate this important information because this is some very important information. And we got one member that is coming back in again. Ms. Solomon is coming back in. But thank you all so much for joining us. And as I said, we are stronger together. We need to amplify our voices. And if you think your rights have been violated, don't be afraid to speak up. Contact your local president, contact your UNISERV. If you think you have an issue that you can organize around, make sure that your UNISERV has that information as well. And thank you again for joining us. And I'm going to say good night, everyone.
Thank you all. Appreciate you.
Good night.
Good night.
Good night. Thank you, Mike.
Good night.
Good night, everyone. Thank you, Ms. Solomon, for coming on.
Good night.
Well, good night. I'm sorry I missed most of it.
I see you, though. I see you.
All right. Thank you.
All right. Y'all have a good night. Bye-bye.